Hello, everyone. Welcome this is our second in our series of sessions with the New Mexico Family Advocacy Program that is being implemented in the 13th and 2nd Judicial Districts. NMFAP, if you're not familiar with it, is an interdisciplinary team of lawyers, social workers, and parent mentors. We work effectively together to provide quality parent representation in the court system so that families get the proper advocacy they need and support for reunification or other preferred outcomes. Participants in our community of practice, in this ECHO community of practice, will receive professional development from experts and early adopters of the NMFAP model. At the same time, we'll learn best practices and collaborate to solve complex issues of providing quality parent representation in the court system. So welcome.
Thank you, Leslie, and I'd like to introduce myself. I'm Dr. Michael Stanton. I'm co-facilitating with Leslie Jones, and I'm here to help support this amazing community of practice that's one of the first of its kind in the country. We're very fortunate today to have a great presentation that we'll come to in just a moment. But first, we'll do introductions here at the Hub, starting on my far right.
Hello, everybody. My name is Laura Arguelles, and I'm going to be your technical support. If you have any questions or problems, you can reach me in the chat, which tells me right here. If you want to look down at the bottom of your window there, you could see a chat button. If you click on that, that can open up. You can chat me privately. Also, if you are connected by phone, you would use *6 to mute and unmute.
And again, I'm Michael Stanton. I've been working with the ECHO Institute at the University of New Mexico to help transpose a very successful model for professional development for folks in remote and isolated locations around the state. And I'm helping providing technical assistance to the work of this amazing group.
So today we have our presentation is Understanding IEP Law and Special Education. Our presenter is Matthew Montaño. Our learning objectives for today are, we have 3 learning objectives. One is that by the end of the session, what we hope you will be able to do is to describe the key elements of an individualized education program, that you will be able to relate the legal expectation of parent-student participation, so we're better able to support clients and family involvement for lawyers and social workers as it relates to our cases, and that we'll understand the procedural safeguards in special education and how they can support the work of legal representation. So our presenter today is Matthew Montaño. He is currently the Deputy Commissioner of Special Populations and Monitoring at the Texas State Education Agency. Matt is a former Deputy Secretary of Education for New Mexico PED, a former special education teacher and principal for Bernalillo Public Schools. So welcome, Matthew.
Thank you. Can everybody hear me okay?
Yes.
Awesome. Awesome. Thank you for inviting me to be part of this presentation. I'm looking forward to it. Just a little bit of background. My work here in Texas is really around the work that I'm going to kind of describe at a high level today. So really providing equity and access to students with disabilities in the state of Texas through enhanced implementation of IDEA. So hopefully I can get a better understanding about this, and then when we have questions, I can definitely go into more detail. I really wanted to start with talking about 6 principles to understanding what the Individual Disabilities Education Act is. The idea is what we call it is federal law, that every state is required to implement the federal law, but also have state law and regulations to formalize the practice within the state. So any state can go above and beyond what the federal law requires, but they can't do any less than the federal law requires, which is pretty significant. Let's see if I can, okay. So the first component of IDEA is, and probably the most important part of IDEA, is the requirement for free and appropriate public education. And I've kind of outlined it in the PowerPoint. I'm not going to read the PowerPoint, but I think that there are a couple of things that have to be understood when students are identified with having a disability, is that once they've been determined to have a disability, the school district is required to provide them free and appropriate public education, which means that it's free, meaning there's no cost, no matter what the service is that is being provided as part of their IEP, that service is free to the parents and to the student. The parents and the student should not have to pay any type of fee. So you have many students who have multiple services, anywhere from speech language pathology to occupational therapy to physical therapy to social work therapy and psychological services. All of those are free to the family. The other main component of it is that it has to be appropriate. And what appropriate is to be specified by the IEP team. Appropriate is the process in which a student has appropriate services so that they have access to the general curriculum. I want to emphasize, and I think I have it in a couple of other slides, special education is not a placement, it's a service, or it's a spectrum of services. It is not a place where a student goes, although public schools still do this, and many people that believe that special education is a place still think that it's a classroom, and it's not really a classroom. It's a type of service that should be delivered within the least restrictive environment, which I'll get into as well. So part of providing a free and appropriate public education is having an appropriate evaluation. So one of the things that is necessary for a student to be able to be identified with a disability, and most of our students identified with disabilities are identified with specific learning disabilities. Part of having that identification is having a comprehensive educational evaluation. And that comes from a variety of sources. So we often think of evaluation as some kind of diagnostic test, but that's actually just one component of it. Generally, the student is identified with having a disability, both from maybe parents referring them. The parents see that there's some type of concern that they see coming home. Generally, this happens early on in kindergarten, first and second grade. If parents don't catch it, generally teachers will catch it, and they'll make that kind of referral based upon concerns that are outside of what would be normal developmental concerns that they may bring. And then classroom observations are generally conducted. So once a student is identified as struggling, there's a process called response to intervention, and now it's actually a new term. It's called multi-tier systems of support, in which the school wraps around that student and kind of addresses the needs that they're identified, and they try to put interventions in place before there's any type of formal assessment. And that usually takes between 4 and 6 weeks, and it should happen in the early years, and often it even happens before kindergarten, but it generally would happen within kindergarten or first grade. But when that does not occur, then there's often a referral for identification. And that referral for identification can come from the teacher, it can come from the parents, it can come from a school counselor, it can come from many different avenues. And once that referral's been made, the school district is responsible for conducting that evaluation within 60 days of the referral. And that 60 days is a calendar, is counted on the calendar year. So it includes weekends, holidays, breaks, things like that. You have 60 days to do it. The purpose of doing a comprehensive educational evaluation is to basically determine what types of educational services the student needs, and are there any related services. So often you might have a student that qualifies with one disability, but then they have a secondary qualifier. So a student with the learning disability might also need speech language services, and that would be a related service that helps them with their appropriate education. And then the final thing is that the final component of the comprehensive educational evaluation is that you want to ensure that you're meeting the educational needs of the child. So one of probably the biggest misunderstanding is that once a student gets the evaluation and that they are identified as a student with a disability, that there's some kind of rote mechanism that the student goes into. But really what that does is that triggers an IEP team that includes the parents that makes some very clear decisions about how to best meet the educational needs of the child. And meeting those educational needs is always targeted toward meeting the general education expectations of non-disabled peers. So next once you have a student that's identified as having a disability, whatever disability that could be, there triggers what you call an individualized education program. At the beginning, it's called an initial IEP, and then annually this IEP occurs every year at the same time as the initial IEP on an annual basis. The IEP, or Individualized Education Program, is the official meeting record of this student's program. Its annual meeting record is reassessing whether the student is receiving the correct services, how they're progressing on those services, what their present levels of performance are, and then are there needs for additional services. So in an individual education program meeting, you might see that at the meeting, the general education teachers, special education teachers, and any kind of ancillary service providers might be providing updates as to what the student is being able to do based upon what the annual goals and objectives were for that student. And they'll be able to tell you what their reading levels are, what their math levels are. If they're in speech language, are they being able to articulate language needs any clearer? Are they making progress in those areas? And it can be a wide spectrum of goals and objectives that the student has based upon their initial determinations when they entered the IEP. And then they annually will assess that, and then annually they create new goals and new objectives, and then try to create really tangible objectives and goals that would be addressed during the upcoming year. You always, as part of an IEP, have to address meeting general education needs, even if they're having goals and objectives outside. You always have to meet general education needs. So students will always have some type of goal or objective on reading and math, even if they have behavior issues that are associated with their disability. The next important component is the least restrictive environment. Least restrictive environment is probably the second most important acronym that you'll learn to FAPE. FAPE is something that all districts understand that they have to operate with, but least restrictive environment is probably the next important component. And what this means is that a student is supposed to be in the least restrictive environment available to that student so that they can meet their educational needs. And what that means is the least restrictive environment is always starting with the general education classroom, which means if you're a first grade student and you have a learning disability, or you have some type of other health impairment, like you have ADHD or some type of disability that's been recognized by the IEP team, the first place that a student should be receiving those services is in the general education setting, which is with their non-disabled peers. So to be clear, special education should be a service and not a placement. Now, there's a spectrum of services that take place for students with disabilities that could change settings. So some students that need more intensive settings regarding some of their therapies could be pulled out of the general education placement. So a student that may be receiving speech language therapy, they might be pulled out for 30 minutes once a week, and then 30 minutes they're in their inclusive setting with the speech therapist working with them or observing them in the general education setting. So there are different ways that services can be met. It's important to know that no student should have the exact same service as another student. If they're getting the same student services as other students, then the IEP is not really being visited with the kind of authenticity that it should be. And then the biggest thing is schools should be creating a range of options for students. It's not that you're in or you're out. It's that you have access to the least restrictive environment at all levels. If you're a student that has some kind of behavior or emotional disturbance, there are certain points in the school that can have that student more accessible to the general education environment. and then certain points in the school that the student may need to be in a more restrictive environment. And that's all dependent on what the IEP team determines on an annual basis. Along with those components of least restrictive environment, when you have students that have to be removed from the least restrictive environment of the general education setting for matters of behavior, every IEP will have a behavior intervention plan, which has to address the specific instances in which a student would be removed or would have some kind of service provided outside of the general education setting. Am I going too fast? It's a lot of information, so I'm trying to get through it so we can go through Q&A. The next important component is, it's kind of interesting, and I would imagine that everybody on this particular presentation is more interested in this component of it, because this is probably where you hit most of your roadblocks. It's no secret that schools are not parent friendly. They're just not built that way. And they're even less parent friendly when it comes to students with disabilities. And it's and the interesting component of that, or the interesting fact about that, is the federal and New Mexico state law and regulation both are very, very clear on the rights and responsibilities of both parents and students to not just attend meetings, but be full participants in meetings and decision makers in meetings. And so one of the things that is required is a parent is required to be at a meeting. The only way that a meeting can, an IEP meeting can take place without a parent not attending is if they've actually formally let the school know that they are not going to attend, and that they're giving the school the ability to carry on with the meeting without them. Or if the school is unable to actually get in touch with the parents so that they can formalize that notice, and they've documented the attempts to be able to formalize that notice, then the meeting could occur so that the student and the IEP can stay in compliance. But those are pretty extreme measures, and there has to be sufficient documentation on the school's part, and it is actually the responsibility of the school, and it's incumbent on the school to ensure that. Additionally, parents are to receive timely notification. Each district has local policies and procedures in how to give that timely notification. My former district used to have a 10-day notification timeline, which would give parents enough time for them. If they did in fact respond to the notification, it gave them enough time to change the date or the time if necessary. Often parents are not notified in a timely manner, and many of the parents that have students identified with disabilities don't have transportation as readily available, and they can't turn around that. It is not the parent's responsibility to make it happen, it's the school's responsibility to make it happen. In cases where a student is being evaluated for the first time, a parent must give consent for the prior to having that evaluation. So when a student has been determined to need to go through some diagnostic battery evaluation, before they can be assessed, the parent must give formal consent prior to that. After they've given prior consent, or they've given consent to the evaluation, a student has been identified, a parent is still asked if they're, on every 3 years, a parent is asked if they, for consent for evaluation, but all the district and the school has to do is offer them consent, but they don't have to actually receive it, because once a student has been identified, they have the ability to continue to assess and evaluate moving forward. Students are required to be part of their annual IEP beginning at age 14, because that is, in New Mexico, the time when students are starting to discuss transition. And what transition means is transition between grade levels for accessing college and career readiness opportunities. So starting generally in 8th grade, you'll start talking about transition and coursework that would lead to either certification or college readiness. And then each year you talk about, in the IEP, you talk about what the students' goals and objectives are for themselves, to see that the IEP is developing a program of study that meets those goals and objectives. And so a student is required to be part of that, and the meeting cannot happen during that time period without a student being part of it, or without them giving the ability for the school to move on with the meeting. It is never in the best interest of an IEP for a student at age 14 or above to not be part of their own IEP and be part of the decision making. So then you have the procedural safeguards, and these are components that are used to create safeguards for both the parent and the student. The parent being the strongest advocate for the student. And essentially, one of the safeguards is prior written notice. Any type of determination that a student is going to receive in the IEP, which could be placement, it could be reduced or enhanced service, it could be additional service, it could be additional evaluation. So you could have a student that has been identified as having a learning disability, and now there's concern that the student might have some type of behavior disorder. The parent would have to receive prior written notice for that evaluation to take place, and they would have to provide consent for that type of evaluation to take place, an additional evaluation to the initial. So prior written notice is essential before any kind of change in identification, evaluation, or education placement can take place for a student. Access to records, and this is generally done on an annual basis, so it's not something that schools are equipped to really handle. So I know that in this particular session, we have a lot of advocates that you're working on behalf of parents. Generally, what we would want to do is we would want to have an inspection and review of a student's records on an annual basis, not on an ongoing basis, because they're not always so accessible. But there is the right and procedural safeguard for a parent to access for inspection and review of all records, and also to participate in all decision-making of that student. And then finally, there's the ability for parents to receive impartiality, which means that there's the ability to request mediation or even a due process hearing. And there's the ability for an independent educational evaluation in which the state, in this case, New Mexico, would provide an independent evaluator if that is a concern. So when it comes to a point where parents feel like there's a contention between them and the district that's not being able to be solved, these are some remedies and safeguards that are provided to parents to be able to work through the process. So a couple of things that I think is important for this group to know and for parents to know is when you have disputes with schools or districts, there's kind of a process that's to be followed, but this process is very clear, and it's for creating an avenue for parents to receive, at the very least, to have themselves be heard. And so the first thing is, if you have a dispute, you have an IEP facilitator and a principal on the campus that can resolve the dispute. So let's say you're in an IEP team meeting and the parent disagrees with the overall recommendation of the team. And the parent disagrees, is not willing to sign. The IEP facilitator, which is generally like an administrator, an assistant principal is designated, or a teacher that has been designated as having the administrative rights, can actually make a decision on behalf of what that IEP meeting requires. The principal of the school can also make that decision. Now, that decision holds if, in fact, once that decision's made, the parent decides, okay, well, now that decision's made, I'm going to go ahead and sign it and move forward with it. Now, if the parent still feels like they haven't had their issue resolved, they now move to the district level, and they can appeal that to the superintendent or the designee of the superintendent. Often it's the special education director or a director of federal programs, or some person that oversees special ed programming for the district. Within that dispute process, every district is required to have a formal process for dispute resolution, which means that there's a formal aspect of a parent filing a resolution of dispute with the district, in which it would be handled without hearing officers, without any kind of formal hearing. They're able to resolve it with some type of process the district has put in place. That process has to follow state guidelines, but every district has different processes. Often there is like an impartial hearing officer that another district provides on behalf of some of these issues. When that particular component of dispute resolution process does not solve the issue, the last component is a formal complaint to the state. And when a parent writes a formal complaint to the state, they have to essentially have two components that they have to be able to formally reveal what the discrepancy is in the decision making, which means that they have to be willing to let the district know that they're complaining and what the issue is. And they also have to demonstrate that there's some kind of harm being done to the student based on that complaint, based upon decisions being made in the IEP meeting. And when they do that, the state does generate an investigation into that complaint and will resolve that complaint in a formal, in many ways. Often, if there's findings for the complaint, the state will write a letter to the district saying, based upon an investigation, we have found that there's some relevance to the complaint and that we're suggesting that they make some changes. When a district disputes that, then there could be a formal hearing to go through the process. Okay, hold on just a second. So a couple things I wanted to put out just as kind of data that are important for us to factor in when we're thinking about students with disabilities and really anybody that has an IEP. There's some national data that is being used to support advocacy work for students with disabilities. And you may, in your roles, have heard about social emotional learning and cultural and linguistically responsive instruction and things of that nature that are meant to address what are traditionally underserved students, kids that kind of go under the radar. Students with disabilities are among that group of kids that often fly under the radar. Even though they have the label of being special education, often there are many things that happen within the school that don't involve or directly take them into account when they're being implemented. And because of that, students with disabilities often get left out. A couple of data points: they're 31% more likely to be bullied than non-disabled peers. And so you think about this as a student that's in kindergarten or first or second grade, and think about a lifetime in school where you're bullied year in, year out, and think about the consequences of that over a period of time and what the consequences of that could be. Because of that bullying and because of other factors, they're twice as likely to be suspended, right? What's most important about suspension of any student is students that are suspended are about 4 times more likely to drop out of school, whether they have disabilities or not. But the biggest thing is when you suspend students with disabilities, they lose instructional time. So all of a sudden, we've now created greater barriers for students with disabilities when we suspend them, right? We already know that they're struggling to be successful in the school setting, and now we're going to kick them out of school, which means that we're putting them further behind. So there's some really damaging policies that we create when we do those kinds of things. Over 1 million students with IEPs miss 3 or more weeks of school per year. That's often related to the top 2 bullets, right? They get bullied. They're not accepted within the school setting by adults or by their peers, and often administrators in the school setting see them as barriers to a calm school setting, as opposed to trying to create opportunities to use their assets. Students with learning disabilities specifically are nearly 3 times as likely to drop out of school. This is really important. Students with learning disabilities are the largest group of students with disabilities, and they're also the ones that go under the radar the most because you don't necessarily see that they have a disability. There's nothing about them that demonstrates their disability other than they may actually be performing a couple of grade levels below in reading or math, and yet they're 3 times as likely to drop out of school. And then finally, a failure for students to receive appropriate instruction leads to their incarceration. About 55% of young adults with learning disabilities have been incarcerated or are incarcerated compared to about 30% of all young adults. I think that statistical difference is really important to recognize, but I would also say that that 30% could be kids that are not getting appropriate services and are suffering from some of the same disabilities as their identified peers. So there are a couple of concerns that would pop out to me on that. And then lastly, the last slide I have just some resources that I would ask all of you guys to tap into. Understood.org is sponsored by the federal government, by the Ad Council. It actually probably does the best job at providing resources to parents about how to be really positive in advocacy as opposed to some of the ways that often parents that come with advocacy groups, they come to schools in an adversarial way, and then the school approaches them in an adversarial way. So understood.org is doing the best work, I think, around trying to change that lens for how parents can approach schools, and also trying to change the way that schools approach parents. I guess that's all of the presentation.
Great, thank you very much. So we'd like to open it up now for questions. If anyone has any questions that they would like to ask Matt, if you do, please remember, that's great, raise your hand, and then you'll need to remember to unmute yourself before you ask your question. So it looks like, Bonnie, you have a question? Did you unmute?
Yeah.
There we go.
Okay.
Oh, yeah. Hi, Matt.
Hi, how are you?
Great to see you again. I thought you had disappeared off the world.
I'm in exile from New Mexico right now for my teacher.
Well, it's good to see you, and thank you so much for all of your knowledge. I really appreciate that. I've learned so much from you already in the past, and I thought this was a really good presentation. Thank you very much for making it very friendly for everybody. So I have a couple of questions.
Okay.
So first of all, as you know, parents' rights, the parent rights and procedures, I know that PED here has tried to make them a little bit more friendly for parents, but there's still, when you run them through the software, they're still at a college level reading. So this makes it very difficult for parents to understand what their rights are, what they should be looking for. And so besides advocates, who else can we turn to locally in New Mexico? How else are we going to get information out to parents about what they can expect? Because a lot of times those parent rights and procedures aren't actually given to the parents until, and I don't know if you know this, but I'm an advocate now, so I'm not actually in the schools or classrooms right at this moment, perhaps for years, I don't know, until we get this fixed. But so they aren't given those parent rights and procedures until either the meeting or after the meeting. They're emailed the parent rights and procedures right afterwards. And then my second question was, what about the PWNs? So the prior written notice. A lot of times those are also not gone over with parents. Parents aren't given any indication of what is going to be done until actually at the end of the meeting when they go over the prior written notice. So what can we do about that? And then also, so I've had situations where I've gone to an APS meeting with a parent, and I was told as an advocate that I'm not allowed to speak. And I don't know if you've heard of that happening or not. Apparently that's kind of recent. So what should we do in those situations as far as being an advocate? And then,
Bonnie,
But
just
one more, please.
We've got other people who have questions. We're very limited for time. So if we could get an answer from Matt to your questions, and I'm sure that he's got his contact information there so that you could follow up with him afterwards.
Thank you.
Okay, so I would say the first thing, and on the first two questions, I will follow up with the state director of special education in New Mexico to present these questions to her, because I actually think part of the strategy that we're putting together here in Texas would love to make that the national model of something that other states are taking into account. We're actually creating some really strong parental advocacy groups to give us a lens, right? Because when you operate from a lens of educationese, if you will, you forget that other people don't understand the lingo and all the acronyms. So we need people that actually come from places where they don't speak that language all the time to be able to give us that feedback. And we're actually operationalizing an outreach process right now around the state of Texas. I will talk to Deborah Dominguez-Clark at the state of New Mexico and talk to her about these two specific questions. As far as the right to speak, everybody in the room has the right to state something, especially if the parent gives that right, especially if the parent is formally recognizing an advocate to be a speaker in the meeting. You may not have the right to vote on the actual action if the parent in fact is in the room, because everybody gets one vote and the parent can't create more votes by bringing advocates, but you could get a right to speak based upon parental. Now, sometimes it happens that there will be an attorney advocate, and then the district will say, we can't have you participating unless we have our attorney available as well, which is, I would do the same thing as a former principal, especially if it's going to be an adversarial meeting.
Okay, thanks. I think we had somebody else. Kylie, did you have a question?
Hi, I do. My question is just a little bit about the 504 plan that they do with kiddos and kind of what the basic difference between a 504 and an IEP is. And then are the parents entitled to the same rights with a 504 versus an IEP? Do they have a say that goes into effect, or is it pretty much at the school's discretion?
It's not at the school's discretion completely, but there aren't the exact same safeguards. So 504 is Section 504 of the Americans with Disabilities Act. So 504 is most generally used for students that are having like physical access issues and or some other issues in which they can't get physical access or you know, like health access. So a lot of times you'll have 504s for students in that have like severe asthma or diabetes or things of that nature, that they would have a 504 plan in which they'd get priority access to like the cafeteria or to the nurse, or they have like a permanent hall pass if they need to go. There are certain kids that have like certain bathroom needs that they have to go and they don't need to ask the teacher for. So those are some of those things. A 504 is covered by the Americans with Disabilities Act though. So once a 504 is decided on, and it is, once again, it's not like an IEP, but it is a committee that includes the parents. Once the 504 is decided on, it is the responsibility of the district and the school to follow all aspects of the 504 as have been agreed upon. They don't have the same procedural safeguards though.
Okay, thank you.
Is there anybody else? Kentrell?
We can't hear you, Control.
Yeah, we can't hear you. Nope.
Oh, can you hear me now?
Yes.
Okay, so I saw the thing that you talked about, the grievance. In the last IEP that we were in, they had the district special education director in there, as well as the security for the entire district in there. And when the mom asked, hey, I don't agree with what's happening right now, all they did was point to the booklet that they handed her, those guidelines, and they told her that she could read, and that's how she could dispute what we were talking about. They were making an assumption about a child only going to school for 2 hours a day. They were doing an abbreviated schedule. And so we said, hey, we'd like to negotiate. We'd like to change some of this. We'd like to talk a little bit more about this. And the answer we got was, this is our recommendation. So when you said they get a vote, I don't remember having an opportunity to vote.
And that's actually, so I think like, obviously this is a very high level presentation. That's one of those very specific areas where you should not, like, if from a parent's perspective, I would not sign off on that IEP. I would not acquiesce to the decision in the IEP. And there are a couple of safeguards you can have. You can obviously go through a dispute resolution process at the district level. Sounds to me like they'd already shored that up because you have the district director there. So the other thing you can also request is a facilitated IEP, which is an independent facilitator. The state can provide a facilitated IEP, which is independent and impartial, and facilitates the IEP on behalf of the district. And that's one thing that can be requested. Generally, that's, you know, it's kind of the last gasp, but that is something. Matter of fact, I just received a request, I think like 2 weeks ago, for us to provide one for school in San.
Okay, thank you. Okay, I think if there are no more questions, we're ready to move on to the next segment, which is our case presentations.
Thanks, Leslie. And thank you so much, Matt. And Bonnie and others, if you still had a question for Matthew, go ahead and put them into the chat window and we'll forward them on to him. And when he has a moment, maybe in the next day or two, he can respond by email and we'll share those with you as well. As well, take a look for his PowerPoint through the link in the email that Laura sent you, our network coordinator. So for those of you who are new to our ECHO model of this professional learning, as you saw, our first segment was having an amazing specialist and Matthew Montaño, and we'll have others throughout the year, a specialist in a particular area in a 25-minute workshop presentation, and then discussion and clarifying questions afterwards. The next part of the segment is also very important. We call it the time where all teach and all learn. It's our community of practice and our collaborative problem solving and case presentation. And Matthew, if you still are able to stay with us for another 15 to 20 minutes, we would love to have your input. Again, the process is we have 2 case presentations. We'll see how our time goes to be able to get both in today. But we'll have the presenter just read through a description of that challenge, that complex challenge that they've been grappling with, that would like to get some advice from all of us in the network today. And then after their presentation, there'll be some very quick clarifying questions. We'll go around the network and then Mr. Montaño may be able to ask maybe a clarifying question as well. Then we'll go back out to the network for recommendations. And again, raise your hand, just like Leslie mentioned, so we could see you either electronically, like Kylie figured out. Thank you, Kylie. Or you could raise it, just in that. I would ask Brian and Ann and others of you who are joining us to go ahead and turn your cameras on if you can, so that we can recognize you for this important segment. And then for those, Laura will be taking notes of our recommendations, and we'll share both the case and the recommendations out with you by the end of the week. So we'll start right away then with showing our first presentation. I'm going to bring the case up to the screen for us. And each session we will, each ECHO professional learning session will have 2 different types of cases that we'll present. The first one is being presented by Caitlin DeFiore, who's one of our amazing social workers. Caitlin, is this the one? Yes. And it'll be a particular challenge that you're going to share with us right now.
Hi, everyone. Thank you for joining us today. So an issue that we run into a lot when we're working with parents in CYFD cases is that IEP meeting dates are not communicated to the CYFD office or to parents. A lot of times what happens is the foster parent's told, and sometimes the foster parent tells CYFD, sometimes they forget, and the parent doesn't know about the meeting. In a lot of our cases, the parents are appointed by the court as the educational decision maker, or at least sharing that responsibility with the foster parent in the case. And when they're not able to be a part of the IEP meeting and decisions are made, they don't have the opportunity to object to that. Some of the responses that we've received from some of the schools when that happens is that they can't reset the meeting because it's already occurred. So things that we have tried is asking CYFD to make sure that they know the dates of those ahead of time and that the parent is informed of that. And we've tried calling the schools with parents to get that information, but what happens is the school doesn't give us any information because they see that the child is in CYFD custody. So I guess my question to the network would be, what are some ways that we can ensure that either parents and CYFD are involved in those meetings, or that meetings can get reset when CYFD is not able to be present because they do have legal custody of the child?
Thank you, Caitlin. So again, Caitlin is asking us to kind of help brainstorm with her for advice to foster better communication among all the parties around the details of these IEP meetings and their schedules and the related details. Is that right?
Yes.
Great. So we'll start with a minute or two, and Dominica, since you're kind of at the lead in our spoke out at the second judicial, if anyone there has a question, just have them raise their hand, and we'll see you, and we'll definitely be able to stop as well. Who has a clarifying question to maybe probe a little bit deeper to Caitlin to help you formulate your recommendation here in a couple minutes? Again, raise your hand, introduce yourself by name and where you're calling from. That would be great. Yes, from the second judicial office there.
Hello, so I'm Dominica Montaño. I work with the 13th. My clarifying question would be, who registered the children into the school district? Was it the foster parents? Was it CYFD? Was it the bio parents? And does that have any play in who gets notified? And that question may be for a response from people who work with parents, or maybe from Matt as to how the schools would respond to whoever it was that registered the child.
I think in a lot of our cases, it depends on does the child stay in the school that they were in at the beginning before the case occurred, or were they moved because of the CYFD case?
Thank you. Clarifying questions for Caitlin to help formulate some recommendations here in a minute. Bonnie, would you like to go ahead? Unmute.
Scroll down just so that I can see
Sure.
the written part of it.
Let's see. Sorry about that. Okay.
So my question is, what kind of actions have been taken, would have been taken before are we talking a particular meeting, or are we talking about just in general, this is something that's happening?
We're talking about in general. We have it happen in lots of the CYFD cases, which we're a part of. We've tried talking to the schools. We've tried asking CYFD to make sure they have that information ahead of time so that everyone can be there when they need to be there.
And I'm wondering what kind of actions have been taken in the past? Like, has there been communication with the PED, Special Education Bureau, before? That kind of thing.
Bonnie,
Can you
I'm
say
sorry.
that a little louder? We're having trouble hearing you.
I'm sorry. I was wondering what kind of other actions have been taken previously. If there's been contact with the Special Education Bureau, or letters written to the school, written communication with the school about this, and about this with this, like, is everything in writing?
I don't believe on the cases I've had that it has been. I think what we've really tried to do is get CYFD involved in it, since they are the legal guardians, and try to make changes that way. And we've had some success in schools giving more information to bio parents, but it hasn't been widely successful.
And let Christy and then Matt, I'd like to give you a moment if you have a question that would help, and we'll go right into recommendations. Go ahead, Christy.
So maybe a little feedback. In the cases that I've had, CYFD actually has really tried to engage the schools, and pretty much the response we get is, oh, sorry, we already held it. We didn't tell you. What can we do about that?
I think my clarifying question is the meeting is already held, and who's representing the child?
The foster parent is typically the only person who's there. So CYFD, who's the legal guardian, is not there, and the parent, who is the educational decision maker, is not there.
Okay. Okay.
Thank you. Bonnie, we have time for one more clarifying question and we can go right into recommendations. Go ahead.
Custody documentation and court documentation, has that been transferred? Did you hear that?
Did you see Kentrell's?
Yeah, I saw Kentrell's answer. I think in some of the cases we've had success with that. In some of the cases, their response is, well, we already held it. You'll have to wait till next year.
You mean after you've asked them, made sure that they have the custody? Like, have you guys made sure that there's custody information, the court documentation?
In some of the cases, yes, prior to that. In some of the cases, we haven't been able to because we didn't know that the IEP was coming up.
So, Cantrell, I know you have a comment there. Would you want to share, or should I share that directly, or we'll talk about it later? All right. Thank you. I just wanted to be clear. Thank you, Cantrell. All right. We have a few more minutes for recommendations. What are some thoughts that would help Caitlin for to support her work in similar cases in the future? Who would like to go first? And again, we'll do this kind of popcorn style so that we could just, and Laura will be recording what she hears, and we'll share these recommendations with, obviously with Caitlin, but with all of us within the network, as we can all learn from this great discussion. Who would like to go first? Yes, Matt, thank you.
So the first thing that jumps to mind is you have to make sure if the student's staying in the same school that they were already in, they just have a foster parent now that is going to take that guardianship for them under CYFD's supervision, then they need to immediately formally document that. And I would actually say that whether the student has an IEP or not, when a student is being placed in foster care, it probably is in the best interest of the student for CYFD and the foster care parent to let the school know whether they have an IEP or not. Part of my role here in Texas is actually to oversee the all students in foster care. And we're struggling with that because we often don't know what kind of services that they're receiving, whether they have an IEP. So that would be the first thing. If the student is, because their foster placement is outside of their regular school district, then I think it's really important for when the foster parent goes to register that student at school, that the CYFD caseworker is with them, or at least is part of, is registered as one of the local decision makers in that. So I think that would be the thing that I would do. As when I was a principal, when I would have a CYFD caseworker a lot, or when I'd have a foster parent, and I knew that the student was under CYFD supervision, then I would ask them to bring the CYFD caseworker to be part of that, the registration packet, so that it's part of what we have to do for notification. Because if it's in the registration packet, it's a requirement of the school. If the school doesn't know any better, they can actually plead that they don't know any better, right? So it's really incumbent on CYFD and the foster parent to communicate that to the school immediately.
Thank you, Matthew. Any other recommendations for Caitlin? Yes, Bonnie?
I have one more recommendation.
Go ahead, Matt, and then Bonnie.
If the foster parent is in good communication with the CYFD caseworker, and the CYFD caseworker is getting late notification and it's probably through the foster parent probably should not attend the IEP meeting. If it's not in the best interest of the student, the foster parent can say, I'm not attending and I'm not allowing the IEP meeting to go forward. The school cannot arbitrarily allow an IEP meeting to go without parental representation. And in this case, foster parent is that parental representation.
Thank you. Do we have any recommendations from our any of our other spokes, our second judicial folks? Yes, Dominica, go ahead. Can you go ahead? There you go.
Hi, I'm Ted Martinez. I'm a hearing officer here in the second. And I'm just wondering, we've identified the department, the social worker from the department, the educational decision maker, foster parents and the parents, what role or can't the GAL, guardian ad litem, take an active role in lending his or her assistance to, from a legal standpoint, to rectify anything that is not going correctly with regard to their child client?
Well, I don't know that I can. I mean, so as a GAL, I have, when I have done that, because I have represented parents and also acted as guardian ad litem for children, I have attended IEPs. It hasn't been necessarily under these circumstances. I mean, the fact is, if I know about the IEP, then chances are CYFD knows, and the bio parents know, and so we're all there. I think that what the guardian ad litem might be able to do most effectively is to understand these processes, because and the rights of the parents, because I think they're seen as often as being less adversarial. They're there to advocate for the child. They're seen as an ally, I think, to the school. But if they know they can raise those issues that Matthew was talking about in terms of what the parent has a right to have, and they may understand, because they're trained attorneys, they may understand sort of the lingo better and be able to communicate that better. They can also, as you all know, the statute gives the guardian ad litem the ability to refer the child for representation in a legal matter. So they actually have that hammer, so to speak, of saying to the school district, look, if you're not providing these services that the parent is really saying the child needs, the foster parent saying they need, etc., then I can hire an attorney to represent this child against the school district, and that they have that ability.
Thank you. So, Caitlin, did you get some ideas that would help you with this, with your challenging question today?
Yes, I did.
Great.
Thank you, everyone.
Thanks, everybody, and especially want to thank Matthew and others. Excellent questions and some great ideas. We want to also, we still have a few more minutes in our session as we go getting close to the 1 o'clock hour here. And Mr. Montaño, I know you may have a whole slew of meetings this afternoon, but we really appreciate if you could stay on a couple more minutes, and if not, thank you so much. But we do have another case. Typically, our second case of each session is a little bit more focused, and it would be representing a particular, what we would call a legal case, or a particular client or a particular family situation. And in this case, I'd like to, before I introduce Leslie and have her share this, I'd like all of us to be thinking on the network to start thinking about your particular complex challenge or disorienting dilemma that you're facing, so that in 2 weeks when we come back, that we could have you all present. We've kind of modeled with Caitlin and Leslie and us as being a little bit more advanced in organizing, but we really, this is your time to really be able to present what is challenging and complex with you. So Cantrell, our hearing officers, sir, judges, lawyers, social workers, all of us can then present a particular challenge. And we have those forms that are kind of, as you saw, just a simple 3-part form, and you can just email directly to our NMFAP Gmail address so that you can get that sent to you, or made available through Box, or you can reach out to Dominica, Leslie, Caitlin, or myself as well. So let's go ahead and bring Leslie's case up to the screen, and we'll have her share so that you can kind of see a little bit different version of what this case presentation segment could be like. So bear with me as I pull this up. And scroll down. All right, Leslie, if you'd like to maybe summarize and kind of go through.
So I'm going to say that. So this is an actual case that where I represent the parent, and essentially what happened is that there was a referral to CYFD. The reason the child came into custody, there were a couple of places that calls came in from, but one of them was from the school, and one of the things that they identified as neglect on the part of my client was that my client had not agreed with what the school identified as the child's needs for the IEP. And so I don't even remember exactly the details, but he may have just gotten mad and stormed out of the room because he felt that he wasn't being listened to. So he has a developmentally delayed 14-year-old, and the school he felt that the child really needed to have a behavior management specialist for at least, some time during the school day, during the week. And the school said no, there was a behavior management plan, but there was not, they would not agree to a BMS. So a lot of what Matt presented today actually gave me a lot more information about that I didn't know about what this parent's rights are and what the options are in terms of the appeals process and all of that. Because basically that's my question. So for this client and then others going forward is how do I advocate for my client so that they don't end up with more referrals to CYFD for educational neglect because they just disagree with the school about what the IEP should be.
Thank you, Leslie. So really kind of looking at what are the ways to help with the advocate for those, for when decisions are not in agreement and
right.
Being able to follow through with that.
And I'm going to say too that the issue that Bonnie brought up, I think directly plays into this, because my client probably read at about the 3rd grade level, the client themselves. And so really, I mean, to get that kind of information, referring them to a booklet is pretty, useless.
Thank you, Leslie. Let's take a couple minutes we'll actually go in with clarifying questions and recommendations right now. So again, just if you have a thought or a question, please just raise your hand and identify yourself. Yes, Matt, go ahead, please.
So the school was recommending a behavior intervention plan or a behavior management plan.
Correct.
And the parent was requesting a BMS.
In addition to, yes.
In addition to the BIP, because that was included in the BIP.
Yes.
I'm assuming, so to set the stage, the student has had consistent pervasive behavior issues that I'm assuming the IEP has been addressing over some time?
There was actually, I think, a change in school because the student went from middle school to high school.
Okay.
I think during that transition. And so it was a new school for the child, but in the same district, and I assume they had the previous IEPs.
Okay.
But the child kind of cycled, I have to say. I mean, that there were times when her behavior was less disruptive, but then she would go through periods where she was quite disruptive.
Thank you. Bonnie?
So I would want to know if there were behavior intervention plans in place prior. And so if the paperwork had been requested from the previous school and like the history, and then also what kind of data is there that shows what kind of interventions they have tried to do before, because the RTI process or the MLSS, I'm sorry, I can't remember what you said, Matt, the new system for the steps that have been taken prior to help the child besides going straight to the behavior intervention plan. That would also for data as well.
Thank you, Bonnie.
Right. So my understanding is that she has had behavior intervention plans prior to this. Whether or not she had one in place right before she came to this school, I don't know. There was a period of hospitalization in between. So she was at the middle school, then she was hospitalized, then she was at the high school. So I mean, clearly there was some, emergent needs that came out. She ended up hospitalized, So, but yes, there were before. Yeah, Matt? Nope. Is muted. Can you hear? I'm sorry.
Hospitalized for the same issues that are displaying themselves as behaviors in the school, like related, like mental hospitalization?
Yes.
Okay.
I'd like to take a moment because we have several folks that are joining us without video and I can't see you. So if you would like to go ahead and unmute yourself, Lee and Jessica, Andrew, and Kylie, during this last couple minutes, and we'll provide some recommendations and thoughts for Leslie for her complex case.
So one of the things, if I can, because one of the other questions that I had in there is, Matt, I'm assuming you know the answer. There may be others in the group that know the answer, but my understanding is that the behavior management specialist is usually paid for by Medicaid. Is that one of those that the school gets reimbursed? So could my client have gotten a referral, like say from her therapist for a BMS, and if Medicaid approved that, basically just tell the school, guess what, she's approved, and so this BMS is going to come to school? Can they do that or not?
So they can. So part of the IEP team is to take in any external kind of referral, whether it's a physician or a psychologist or a psychiatrist, take that as consideration for decisions that would be made in the IEP. But just having that referral you couldn't prescribe the school to do something like that. That's not within the law in New Mexico, and the federal law doesn't allow for that. I think one of the concerns that would happen is that you obviously have established that the student, because of the disability around mental health, has already been in maybe the most restrictive environment because they've been hospitalized for it. So that's the most restrictive environment. The goal of a school is to place them in the least restrictive environment. Having a BMS with them would be far more restrictive than other environments within the school. But within that spectrum, they've already been in a more restrictive environment in hospitalization, right? So I think the argument would be that the BMS could be kind of a bridge or a scaffold for them to get back into a less restrictive environment even than that. But I think there are a couple of questions that I have is, part of the issue that schools have is they can never use, if an IEP indicates that they have to provide a service, they can never use the funding source as a reason to provide it or not. That whether Medicaid pays for it or they have to take it out of their general fund, once a service is determined to be needed and required, then the district is on the hook for it, however it gets paid for. And even if it's Medicaid, it still has to get parental consent to bill Medicaid. It has to get parental consent to bill private insurance. And if the parent were not to give that consent, the parent would still be on the hook for it. I think one of the concerns I always have with BMS is it sounds really good, but those are only as good as the quality of person that's in the service, right? That's doing it. It's kind of like teachers. All of us love teachers, but there are really, really good teachers and there are some not so good teachers, right? And so like the BMS service, we have to be really, I would just say as an advocate, you want to be really cognizant of who's being asked for and who's serving in that manner. My principal experience, I had really great experiences with a couple of BMSs, but I actually had some really horrifying experiences with a couple. So,
some great advice. So you've got some ideas to help you with how to address this BMS issue?
Yeah. Oh, Cantrell is.
Cantrell has
Yes.
some.
Oh, she's leaving. Okay.
Yeah. Thank you,
Okay.
Cantrell.
So we have
And
4 minutes left.
I think we have time for one more recommendation, and Cantrell did leave a recommendation that we'll add into onto the form for you separately. Okay. Bonnie, one last recommendation before we finish up. And while Bonnie's talking, excuse me, Bonnie, Laura has posted the survey link in the chat window. This would really be helpful if you could take a few minutes before you leave today, leave your office for your next appointment, or maybe at the end of the day or first thing in the morning. Your feedback for us, your reflection, your thoughts, maybe even continuing questions will be looked at and read by our team and at the hub here, and we'll be sure to get back to you with any other recommendations. And this will help us improve our service to you as leaders of this community of practice. So Bonnie, go ahead.
Thank you, and such great suggestions by Matt. He brought up so many wonderful things.
A little louder, please, Bonnie.
So many great suggestions by Matt. He brought up a lot of really important things. I think what it comes down to is that I think it's really important whenever dealing with students that have special needs, that have disabilities in any of these situations, it's important to have people there who can be part of a team that can make recommendations. And even if there's somebody doesn't know something, it's so complicated. You know, the special education IEP law is just very complicated. So I think it's really important to have someone there that you can gather suggestions from. So I'm grateful to be a part of this team.
Thank you, Bonnie, and thank you all of you. Leslie, if you'd like to we got some ideas?
Yes,
if you'd like
I
to
definitely have more information to work with and more information to guide my client going forward, right? Because he's going to be advocating for many years going forward with his child. So I think we're done with this session. We've just got a couple more minutes. I think Mike reminded you about the feedback. Please take a look at that and give us your feedback. Our next ECHO session is April 30th, and our presenter will be Susan Burns, LCSW. She's at the New Mexico School for the Deaf and former field education coordinator and assistant professor at the New Mexico State University. She is an extremely knowledgeable person. I think her presentation is going to be really wonderful and helpful, and she's going to be talking about the importance of clients receiving the right therapeutic modality. That is something that I think we all face in our work. I'm also going to piggyback on what Mike said. I'm hoping that some of you will have cases that you would like to present for that session, because that's something that we've all dealt with, not getting the right services for our clients. So if you have it as a general issue, or if you have a specific case that you would like to present, I really encourage you to get that to us so that we can put it on the schedule for the next session. Thank you, Leslie. Again, I want to thank my former leader here in New Mexico, Matt. Thank you so much for just an excellent presentation. A big thumbs up. And our loss is Texas gain. Thank you so much. Thank you, Matt. Thank you, Matt. And for those of us at the Hub, if you'd like to kind of stay online for a few minutes afterwards so we could have a quick discussion. But thank you, the rest of you, thank you so much. And safe travels, especially those of you in your cars joining us. Kylie and Catherine, thank you so much. Have a great day. We'll see you in 2 weeks. Thank you. Bye-bye.